Chapter 3, we cover torts, which can be personal wrongs committed, and then we'll also cover product liability, which is going to be more for corporations and businesses. So the basis of tort law is that it is a civil wrong, so not a criminal wrong. You know, a criminal wrong, the police would come and we could face jail time. A civil wrong is something that the police are not necessarily going to be involved in. They could, but it could just be between two people and you go to court. So again, and if you go to court, so say, you know, think about like a Judge Judy episode, those are going to normally be torts. But when you go to court, you're suing for money normally, but we call that legally, we call that damages. And then there's different types of damages. So compensatory damages are designed to reimburse us for our losses. So if we specifically had something happen, maybe medical bills, lost work time, maybe damaged property, you know, things like that, lost rent, and we actually have dollar amounts that we're looking for. You could also ask for pain and suffering, you know, costs associated with that. Then there can be punitive damages that the court will award. So when the court awards punitive damages, it is designed to punish the wrongdoer, to kind of set an example, to say we are not going to tolerate this. So for instance, with that Stella who got burnt with the McDonald's hot coffee years ago, the courts awarded her punitive damages. She did not necessarily seek those or feel like those were compensatory. The courts did it because they wanted to show McDonald's that, you know what, you need to live up to the standards that you've set for all of your corporation offices and your franchise offices or restaurants. If they say that this is what they maintain quality standard-wise, that's what they need to do. Well, obviously that coffee was not up to their quality standards. It was far too hot. So then the court does that just to punish that person and to set an example. Now, and this is a question I ask a lot on tests, like what are the defenses? So the defenses are when the person is charged with the wrongdoing, well, what can they say? So they come back and say, okay, hey, I get that. So like to use that Stella example, they may have come back and said, well, we warned her that it was hot and we, you know what I mean? And we didn't recommend that she put it between her legs or whatever she did with it. We recommended that she keep it in the cup holder. We offered her a cup holder. I mean, those are things that they could try to come back and say, well, had she done those things, it would have reduced her losses. But that's just an example. So, I mean, I feel like all court cases, whether it's between individuals or businesses, people always have defenses that they're going to try to use to reduce those damages. Intentional torts against persons. So again, those are going to be, you know, again, more individuals, not corporations. Assault and battery. So assault is when you are actually believe that there's a threat of harm. So the harm hasn't happened yet. The assault is just, I believe it's going to happen. The battery is the actual physical contact where if someone threatens to beat you up and then that's an assault. If they continue to beat you up, that would be the battery. So a lot of times we hear assault and battery together because they do kind of go hand in hand. The defenses to it, so a person being charged with assault and battery could say, hey, I was just defending myself. The person threatened me first, or maybe we were street fighting and there was a consent to it. They agreed. Maybe they came onto your property and you had a baseball bat and said, hey, get off. So those kind of things. And again, the courts would hear that and make a decision. Another intentional tort is false imprisonment. So that would be confinement against another person's will. So obviously that sounds horrible. It can happen in cases where maybe you don't think about it as false imprisonment, but like if you are suspected of being a shoplifter and the store security comes and takes you back to the office, there's only so long they can hold you. If they would go beyond that time frame, that could be considered false imprisonment. Or like airport security is known to pull people out of bars or out of airplanes and then detain them in areas. And again, if it goes beyond a reasonable period of time, it could become false imprisonment, and those people could then sue. Infliction of emotional distress, I feel like we hear that a lot. That's a lot of times, it's a little bit more of a touchy-feely type one, like how can you really prove emotional distress? So what the courts are going to look at is to say, okay, was this intentional act so extreme that or outrageous that it really would have caused for just abnormal mental anguish? So again, that one's going to be a little bit more of a gray area one to prove, but it depends on the circumstances. Then we have the invasion to your rights to privacy. So that's something that's happening a lot online with, different people fishing for personal information and trying to steal people's identities in order to get credit cards and get loans and things like that. So that would be an appropriation of the identity. Then sometimes it could be like if we go down to that last bullet point, like using somebody's likeness. So for instance, like say if you open a restaurant and say, hey, this is Elvis Presley's restaurant, and you have all the, Elvis Presley pictures and memorabilia and all that kind of stuff, that could be an appropriation of the identity. If a person could be confused to think, well, is Elvis Presley actually associated with this restaurant? That type of a thing, and then you're not paying anything to the family. You just thought it was a cool idea to open a restaurant like that, and then you're kind of using that likeness for your profit or your gain. So that could be another type of an appropriation. Defamation of character. That is when you're going to say something publicly against somebody's good reputation or their character. So the key to that is publicly. So it has to be said in front of a third party or online where many people could read it. If it's a written statement, then that is libel. If it's just verbal, it's slander. So the damages for slander have to be a little bit more specific. You have to prove that you actually had a loss. Because again, it's a moment. You say it and it's gone. If it's in writing or on the internet, it can always be pulled up later. So some defenses to defamation is that it's actually true, that when you said that this person has not, has cheated on their taxes for the past 5 years, it's actually a true statement, and they actually have, and maybe they're being investigated by the IRS. Then that's not defamation. It's just the truth. If it was privileged communications, so you went to court and the courts called you to testify, obviously you need to be honest with the court systems. So that is not going to be considered defamation of character. If it's actual malice, that is required not for people like you and I, but for celebrities. So you figure celebrities have paparazzi who are out watching them all the time, always saying something about them. And some celebrities feel like, well, hey, any publicity is good publicity. Other ones are a little stricter on that. But so they would have to be shown to be actual malice. So like there's really no grain of truth to it, that the paparazzi is just making it up totally to sell a magazine or sell an article. Okay, then we get into fraud. Fraud is another very common thing that people sue for. I mean, I feel like if you listen to the news and people are charged with fraud all the time. So there's elements to fraud. So there has to be a misrepresentation of a material fact. So basically that's a lie with the intent to deceive, which again is another kind of definition of the lie. If we tell a lie, we want people to believe it, and we know it's untrue. The innocent party then relies on this deception and they suffer some sort of loss, and the misrepresentation or the lie is the cause of their loss. So, and then it talks a little bit about puffery. Puffery is allowed. Puffery is just simply an expression of your opinion. So, if you're a salesman, you're going to have a great opinion of any product you're trying to sell, and you might exaggerate it a bit, but it's not actually fraudulent. Now, say you're selling a car that was underwater. You pulled it out of a lake. It was submerged for 2 months, and then you fixed it up to the best of your ability and put it up for sale, and then you did not disclose that information that car was underwater. That would be a misrepresentation of a material fact with the intent to deceive. And then if the person pays you whatever the top price is for that car and they end up buying it and having all kinds of engine problems, they could come back and sue you for fraud because they believed your lie and then they suffered some sort of loss. Then the frivolous litigation, you can't be sued out of malice. There needs to be grounds. The court's probably not even going to hear the case if it's frivolous. Then there's wrongful interference with contracts, which comes into play more when we're dealing with businesses. So if there's a valid contract between two parties and a third party knows of this contract, they cannot intentionally cause the other person to breach that contract. That would be considered a wrongful interference with contracts. Now, I do feel like there was a time with our cell phones when we used to have to sign 2-year contracts. Those cell phone companies always tried to instigate you to breach that contract with that other cell phone provider. Now I feel like we don't have contracts as much anymore, probably partly because of this, though, because I'm sure there were laws to protect both sides, and then it became more of a legal complication. Now, the defense to a wrongful interference with a contract is bona fide competition. So that could be what the cell phone people said. Hey, I know that these people have contracts, but we're a better provider. We'll give them a sign-on bonus that'll pay for their contract early termination fees on the other one. And it's just bona fide competition. May the best business survive. Wrongful interference with a business relationship is not contractual then. So then if you know that this company has, it operates on the corner of a busy intersection and you knowingly go there and try to stop customers from coming in or stop their supply truck from delivering them goods, again, it would have to be something pretty extreme to actually where you're actually, or you're standing at the front door saying, don't go in there, there's horrible things about this business, like that type of thing where you're actually interfering with the company's ability to service their customers. Again, bona fide competition is always a defense as long as you're not doing anything that's, very, very derogatory or predatory in nature. Then we have trespass to land. So basically you can only enter onto somebody else's property with their permission. So defenses to that would be, what if somebody was in danger? So what if you heard someone screaming, help, help, and you ran onto someone's property to then help them? So you were not invited, but you heard their calls of distress and you came onto their property. Trespass to personal property is when you take someone's, so it's not their real property, but their personal property, their bicycles, their textbooks, their computers, their phone, things like that are personal property. So if you were to take that or somehow stop them from being able to use it, that would be a trespass to personal property. Conversion is actually stealing the property. So it's not only you're just withholding their enjoyment of it, you have actually taken it and have confiscated it and acting like it's your own. And then it does talk about even if you were in property, if you end up buying stolen property, you can still be liable for conversion because you have somebody else's property. So you have to be careful of that. Disparagement of property. So this is almost like defamation of character, except for now it goes to a business. So instead, like defamation of character was more for an individual, this is more for a business. So if you say a statement that says that the person does not even have the right to sell that property, they don't even have good ownership, that would be a slander of title. If you're going to say something untrue about their product, the quality of their product or service, that's going to be a slander of quality. So again, you just have to be careful. You're always entitled to your opinion, and a lot of times companies ask for feedback, but there's a level between giving honest feedback and then defamation of the business itself. So that would be more in that slander of quality. Negligence is a big one, so you want to understand negligence because we kind of carry that forward in a lot of future chapters. But negligence is when an individual or a business or a professional of some sort has a duty of care, they breach that duty, the breach causes an injury, and that there is some sort of an injury. So you have a duty, a breach of that duty, there's cause, and then there's an injury. So let's use one that probably everyone's familiar with. As a licensed driver in the state of Ohio, I have a duty of care. I am supposed to stop at red lights, and I'm supposed to stop at stop signs, and I'm supposed to go the speed limit, and I'm not supposed to pass buses, you know what I mean? On and on. We have a list of rules of traffic laws that we need to follow, and that is our duty of care. If I don't do that, if I don't stop at the traffic light or I don't stop at the red light, I've breached that duty. Now, if that's all that happens, there's no negligence. I mean, I could get pulled over by a police officer, but there's no one can sue me. Now, say somebody was crossing in front of that stop sign and I blew through it and I hit them. Now, then that's negligent. I had a duty of care. I breached the duty by going through the stop sign. I hit an innocent pedestrian and caused them injury. So then now I'm negligent and they could sue me. So again, that duty of care can be different levels. So when we're just talking about in general, the reasonable person standard is what we use. Well, what would a reasonable person do? So in my example, a reasonable person would stop at a stop sign. So that's unreasonable to not. We don't expect people to not stop. Now, duties of landowners where you own a business and you're inviting people to come onto your property and either, enjoy a good meal if you're a restaurant or shop for product, you have a higher level of care, a higher duty of care. So you need to keep your common areas safe. And if there is anything of danger to the consumer, there needs to be warnings. There needs to be signs up. Something needs to be partitioned off if the floors are wet or there's some sort of an unsafe area. Duty to professionals such as attorneys or CPAs or doctors, they also have a higher standard. They have a higher duty of care that they need to maintain, and normally they're certified, and their ethical standards and everything are going to be a little bit higher. The injury requirement, again, you actually have to suffer injury. So you can't just say, well, hey, you blew through that stop sign, you could have hit me. If you didn't hit me, then there's no injury, so there's no negligence. So if I have that legally recognizable injury, though, then I can sue for damages. Compensatory damages and punitive damages, like we talked about previously. So compensatory damages are designed to reimburse us for a loss. Punitive damages, the courts would award to punish the wrongful act and punish the wrongdoer. It has to be cause and fact, so that you would say, well, if it wasn't for this person's negligence, the accident would not have happened. And it should be foreseeable. So foreseeable is the proximate cause that you could see, okay, even though it might be an extended chain of events, you could see how that could happen and then be responsible for those injuries. So as long as it's foreseeable and it happened because of the breach. So then defenses. So if I'm being charged with negligence, I could come back and say, okay, well, there's an assumption of risk. So say with my example of if I blow through a stop sign and I hit a pedestrian, well, was the pedestrian paying attention also? Were they looking to make sure that it was clear to cross the road? Was it a very, very busy intersection where you probably isn't the safest area to cross? You know how some main intersections, there's green arrows and there's everything else. So maybe that person assumed the risk by crossing this dangerous intersection. The contributory comparative negligence would say, well, were they paying attention? Maybe they were looking at their phone and had their headphones in and they're looking at their phone and they're not even paying any attention to if cars are coming. Was there some sort of a superseding cause, something else to blame? Maybe my brakes gave out and I couldn't stop. So those are things I could come back and try to say, which would reduce my damages. Okay, then our second concept in this chapter is product liability, where we are dealing more with businesses. So the product liability is for manufacturers and sellers, and they're going to also be set to a higher standard. So again, the negligence that could come into play with a manufacturer of the property is that they could be negligent when they designed the product, so they did not design it safely. They could be negligent when they selected the materials. They could be negligent in the production process, so maybe they missed a step or their quality control department didn't double check something. Or same deal in the assembly and testing. Maybe they missed a part and it didn't get tested, and they let a faulty product go through production. Or maybe they just don't even have adequate warning on it. Maybe they didn't think about what consumers could do with that product and didn't give adequate risk or warning of risks associated with it. Now, the thing with product liability is that there's not a contract required, so you don't have to have bought it directly from them. If you have that product and you suffered some sort of injury, you could still have a product liability case. So strict liability is it's a little bit higher level. So, but it's similar. So you've got the product has to be defective when it was sold. The person has to be a manufacturer or a seller of the product. It must be unreasonably dangerous, and there had to be some sort of injury that the person suffered. So again, you can't say, well, hey, I own this product and other people have had injury. You have to sustain the injury, and you could not have substantially changed them or altered them since you purchased it. So you buy a TV set, it explodes and sets your house on fire. So it was defective when it was sold. You're going to go back to the maker of that TV set, and then you've suffered the loss of fire damage to your home, and that would be your injury. So you could have a strict liability claim for that. Product defects. So again, there has to be something that was so dangerous, and that the manufacturer failed to produce a less dangerous alternative. And sometimes those kind of products will get recalled, and then the manufacturer will make a change. It could be a manufacturing flaw where they really intended for it to be a safe product, but then again, due to something in their process, their production process, it ends up being, that they missed a step, something went wrong. There's some sort of error that happened in the production process, and then that resulted in a dangerous product. It could just be a design defect. So they instituted this design. It's produced exactly as they intended it, but then when it gets out there in the market, we realize, oh wait, this is very dangerous. So like the Pinto, the Ford Pinto, was years ago, maybe in the 1970s. It was a very low priced car, kind of a compact car that had a hatchback. Well, the gas tank was located towards the back of the car, and if it got rear-ended at, say, more than 25 miles an hour, it would blow up. Well, people died, and so they knew it. When they designed the Pinto, they knew that was going to happen, but to design it differently would have been expensive. So they actually made the choice to not fix that design defect, to go ahead and market it, knowing there would be lawsuits. So that's obviously a bad example. Could be inadequate warning. So again, there's just not enough instruction given. Maybe to say, like, don't use this in water, don't use this near fire, those kind of things. So then defenses. So what could the company come back and say if they're being sued for injury that resulted as a use of their product? They could say there was the assumption of risk, that the user knew the risk and they voluntarily used that product. So that doesn't fit every scenario, but it could if you were injured with a knife or a gun, something like that. Product misuse, that you used it in the wrong way. So say you buy a can of spray paint and you hold it up to make a blowtorch. So you put your lighter up and you spray it and whoosh, turns into fire. Well, obviously, if it blows up and you're injured, you misuse that product and they're not going to cover that. Comparative negligence, that could be another example, that your wrongful act contributed to the injury. So again, if you are putting that can of paint up to a fire, that would be also comparatively negligent, as well as product misuse. Commonly known dangers, so again, I kind of use that in my assumption of risk example, but obviously we know knives and guns are dangerous. I mean, there's things that we know are dangerous, and yet we still do them and use them. So if we get injured, again, we assumed the risk and we should have known better. Knowledgeable user defense, so sometimes with like business property, so say you're buying a nail gun, well, they might not have all of the user warnings on that because an average consumer is probably not out using a nail gun. A roofer, a licensed roofer, probably is. So they could come back and say, well, if you're a licensed roofer, you know the dangers associated with that nail gun. So you would be a knowledgeable user.